the very definition of what makes you an American, and the invisible shield protecting your fundamental rights are literally on trial this week.
Yeah, and it's wild because we're talking about a core principle from 1898, this idea that just being born on American soil makes you a citizen, that the administration is now asking the Supreme Court to, completely tear up.
Which is exactly why we're doing this deep dive today. I'm your host, and we are going to unpack the breaking news out of the Supreme Court, plus some heavy-hitting constitutional law reviews and historical analyses.
Right. I'm the legal expert for today, and our mission here is really to explore that massive tension between state authority and your personal freedoms.
Exactly. We want to bypass all that dense constitutional jargon and just show you the bare mechanics of the rules that govern your everyday life. So let's just jump right into the news hook.
Let's do it.
Just 2 days ago, on April 1st, 2026, the Supreme Court heard oral arguments in a huge case called Trump v. Barbara.
Huge is an understatement. I mean, at the absolute center of this is Executive Order 14160, which was issued about 15 months ago.
Right. The one aiming to end automatic birthright citizenship for babies born in the U.S. to undocumented immigrants or temporary residents.
Exactly. And the entire legal battle really hinges on just 14 words in the 14th Amendment's Citizenship Clause. So keeping it simple, at an 8th grade level, the text says that anyone born in the U.S. and, quote, subject to the jurisdiction thereof is a citizen.
Subject to the jurisdiction thereof.
Right. And the administration's legal team, which is led by Solicitor General John Sauer, they are totally zeroing in on that specific phrase. They're arguing that just physically being inside the borders, just physical presence, is not enough to actually establish jurisdiction.
Wait, so they're trying to separate geography from legal standing?
It is exactly what they're doing.
Because, I mean, if being born in, Ohio doesn't automatically subject you to U.S. jurisdiction, then what does?
Well, Sauer's argument leans really heavily on this obscure precedent from 1884, a case called Elk v. Wilkins.
1884.
Yeah. And in that specific case, the Supreme Court decided that a Native American man who was born on a reservation was not an American citizen.
Really? Just because he was on a reservation?
Right, because the reasoning was that his tribe was a distinct political entity, so therefore the man owed his allegiance to his tribe, not to the United States government.
Oh, I see.
So Sauer is taking that 19th century concept of allegiance and applying it to modern immigration. He argues that undocumented or temporary residents still maintain a political allegiance to their home countries.
Oh, wow.
Yeah, so because they lack a permanent legal domicile in the U.S., they aren't fully subject to the jurisdiction, meaning their children do not inherit automatic citizenship.
Let me make sure I'm following this. The administration is arguing that an undocumented resident today is legally analogous to a sovereign Native American tribe from the 1880s.
That is the argument.
That is, I mean, that's a massive leap across time and context.
It's a huge leap, but the ACLU is fighting back using an entirely different historical framework.
Right, the 1898 case.
Exactly. Wong Kim Ark. In that ruling, the court looked at this old English common law concept of jus soli,
Which translates to right of the soil.
Spot on, right of the soil. The court basically determined that citizenship comes directly from the physical territory you are born on, completely irrespective of what your parents' nationality is.
It's like, okay, think of it like a debate over a clubhouse.
Okay, I like this.
Does being born inside the building automatically give you a membership just by right of being there? Or do your parents need to have, signed a formal lease first?
That's a great analogy. And the ACLU's position is that the 1898 ruling permanently settled that clubhouse debate. They argue the historical rule grants citizenship by birth within the territory, period.
No formal lease required.
Right. The political domicile of the parents, under this interpretation, is legally irrelevant, unless, they're foreign diplomats or a hostile occupying force.
Okay, but stepping back from the specifics of jus soli for a second, why are we even doing this?
Well,
Why is the Supreme Court using 19th century cases to solve a 2026 border crisis?
It does seem crazy, right?
Yeah. We are debating modern executive orders using cases decided before the invention of the airplane.
Well, that reliance on the 19th century is a core feature of originalism, which, as we know, is the dominant interpretive philosophy on the current court.
Right. Originalists believe the Constitution has to be interpreted based on its original public meaning.
Exactly, when the text was adopted. And the 14th Amendment was ratified in 1868. So to figure out what subject to the jurisdiction thereof actually meant to the people who wrote it, justices look at how the public and the courts applied that phrase immediately after it was written.
They treat it like historical data.
Exactly. They view those historical cases as really the only objective data points available to understand the true boundaries of the law. Otherwise, you're just guessing.
Okay, so deciding who actually gets that constitutional shield, who gets to be a citizen, that's only the first hurdle.
Right.
Once you have that status, the immediate question becomes, well, how hard is it for the government to strip your freedoms away?
And that tension is exactly what birthed the doctrine of substantive due process.
Yes. And looking at the analysis we have from constitutional scholar Erwin Chemerinsky, he points out a massive difference between procedural due process and substantive due process.
Oh, it's night and day. So procedural due process evaluates the mechanics of government action. Like, did you receive a fair hearing? Were you provided legal counsel? Did a neutral judge oversee the case?
Right, the steps. But substantive due process is different.
Completely different. It doesn't care about the procedure at all. It asks whether the government has an adequate justification to take away your life, liberty, or property in the first place.
Let me try an analogy here. I compare this to a parent grounding a teenager.
Okay, let's hear it.
Procedural due process means a teenager gets a fair chance to tell their side of the story before they get punished, like they get to state their case.
Fair enough.
But substantive due process means the parent can't ground them for a completely arbitrary reason. Like, they can't ground the kid just for wearing the color blue.
That is a perfect way to look at it, because that distinction is the backbone of civil rights. The doctrine basically states that if the government deprives a person of liberty in an arbitrary or capricious way, like the blue shirt, the action is inherently unconstitutional.
Even if they gave you a perfectly fair trial for wearing the blue shirt.
Exactly, regardless of how fair the resulting trial might be. So to manage this, modern courts use this rigorous balancing test, and they divide our liberties into distinct tiers.
Which brings us to the numbers game of modern law. Because if you ever wondered why the state can legally force you to wear a seatbelt on your morning commute, but they absolutely cannot dictate who you are allowed to marry.
Right.
That invisible line drawn right through your life, that is substantive due process.
Yeah, and here's how the tiers work. When a right is deemed fundamental, so think marriage, contraception, or directing how you raise your kids, any law restricting it gets hit with what's called strict scrutiny.
And strict scrutiny is tough.
It's basically a death sentence for the law. Strict scrutiny requires the government to prove it has a compelling, vital interest in restricting your liberty, and it must prove the law is narrowly tailored to achieve only that exact interest.
Let me guess. The government almost always loses those cases.
Almost always. It's an incredibly high bar.
But wait, if strict scrutiny means the government essentially loses, wouldn't lawyers try to frame literally every minor grievance as a fundamental right? Just to trigger that impossible standard?
Oh, they absolutely try every single day. I mean, if you sue your city over a zoning law that restricts the height of your fence, your lawyer might actually try to argue that it violates your fundamental right to property enjoyment.
Wow, just for a fence.
Yep. But the courts recognize that if every law faced strict scrutiny, the government would literally collapse. They couldn't collect taxes. They couldn't enforce traffic laws.
Society would just grind to a halt.
Exactly. So non-fundamental rights fall into the second category, which is called rational basis review. Under this standard, the state only needs to show some logical, rational connection between the law and a legitimate government purpose.
And I'm guessing the government almost always wins those.
You got it.
Almost always.
Okay, but substantive due process isn't just about abstract legislation like zoning laws or taxes. It applies directly to physical police conduct, too.
Yeah, under a standard known as shocks the conscience.
Right. The sources bring up this highly visceral example from 1952, a case called Rochin v. California.
Oh, this case is wild.
It really is. So police suspected a man of swallowing drug capsules during a raid. So they literally took him to a hospital and directed a doctor to forcibly pump his stomach against his will.
It's horrifying. And the Supreme Court ruled that forcibly extracting the contents of a man's stomach literally shocks the conscience.
They just bypassed the procedural questions entirely. Exactly. They said the physical intrusion was so arbitrary and so severe that it violated the very substance of human dignity and liberty. So they threw the evidence out.
Okay, the mechanism makes sense, but it highlights a massive structural vulnerability.
How so?
Well, the Constitution does not explicitly list the right to privacy. It doesn't list the right to travel or the right to marry. So if strict scrutiny is the ultimate shield, how does a judge objectively decide what belongs in the fundamental right bucket?
Without just relying on their personal political beliefs, you mean?
Exactly.
Yeah.
How do they decide what's fundamental without just projecting their own feelings onto the law?
Well, you've just hit on the most heavily litigated question in constitutional
A
law
single
today.
vote in the
And
U.S.
it brings
Senate
us
can
directly
freeze the most
to the
powerful
current
government
Supreme
on
Court's
earth.
preferred
But
framework.
right now,
the
a
theory of
political
historical
standoff
tradition.
threatens
The
to
theory of
blow up the
historical
rules
tradition.
forever.
Right.
Yeah,
to elevate
we are
our liberty
watching
to
the
the status
fundamental
of a
machinery of
fundamental
American
right.
lawmaking.
The current
just
majority dictates that the right has to
grind
meet
to an
two
absolute
criteria.
halt.
And honestly,
It
the
must be
physical toll on the
implicit
people
in the
inside
concept
that building
of
is
ordered
about to become
liberty.
very
Which sounds
real.
very philosophical.
Right,
So let's
It
set the
is.
scene.
But
March
crucially, the second part
2026.
is that it must be
Picture the hallways
deeply
of the
rooted
United
in
States
this nation's
Capitol right
history and tradition.
now. Aides
Okay,
are literally
but again,
dragging military
that sounds highly subjective.
back offices.
How does a judge
Oh, yeah.
measure deeply
Staffers
rooted?
are
Well,
stockpiling
we saw
energy
this
drinks by the case.
methodology
Exactly. We are
fully
looking at a
applied.
scenario where
Some would say
senators might
aggressively
actively
applied.
refuse to
In the
drink
Dobbs
water
v. Jackson
just so they don't have
Women's
to leave
Health
the floor to use the
Organization
restroom.
decision.
Which
the
is
case that
wild,
overturned
and it's
Roe
all
v.
because
Wade.
the
Exactly.
Senate is completely
The court didn't
deadlocked
just
over
casually
the Save
reference
the
history.
America Act.
They
Right, that big
conducted
election
a literal
overhaul bill.
mathematical
It's centered
audit
around
of the
measures like
19th
voter
century.
ID
Wait,
requirements.
what do you mean by a mathematical
Democrats are
audit?
aggressively
So in
blocking
Dobbs,
this
the majority
legislation,
focused
and Republicans
specifically on the
desperately
year
want to pass it.
1868. But they lacked
Because
the
that's when the
60 votes
14th Amendment
required
was
to break the
ratified.
Right. They cataloged
Which
the
means
state
frustrations
statutes that
are just
existed at that
boiling
precise
over.
moment in time.
Today,
And they
you have
found that
28
roughly
Republican
three-quarters of the
senators,
states
people
had
like Pete
criminalized
Ricketts and
abortion.
Cynthia Lummis,
So the legal
demanding
logic
that the
follows that if
Senate force a
75% of the
grueling,
nation
physical,
explicitly
talking
outlawed a
filibuster.
practice
They
at
want
the
to
time
force
the amendment
Democrats to
protecting liberty
stand
was
on the
adopted,
floor and talk
then
until
that
their vocal
practice
cords
cannot
just give out.
possibly
And if
be
that
deeply
fails,
rooted
they
in the
want to
nation's
break the standing
historical
rules of the
tradition
Senate
freedom.
entirely to force a
Therefore,
final vote.
it does not
And the real
qualify for
shocker
strict
dropped
scrutiny.
just a few
Okay,
days ago.
but I am looking
Senator
at the
John
critique
Cornyn,
of this
a
method
man who
from the University
fiercely
of Florida
defended the
Law
old
Review,
Senate rules for his
and it
entire
raises a
career,
glaring
just
mathematical and
published
moral
this problem
fiery
with that.
op-ed.
Yeah,
Right,
the critics
saying
have a lot to
Republicans
say
must
about
act
this.
I mean,
now
if
to
we
get
are
this bill
binding our
passed.
2026
he said they had to
rights
deal
to
a
a
fatal
numerical
blow
count
to
of
the
state
rules,
laws from
which instantly
1868,
triggered a massive
aren't we
public call out
chaining
from former
ourselves to
Senator
the
Joe
moral
Manchin.
compass of a
Manchin
society
slammed
where
Cornyn
women
online
and
for,
minorities
well,
had
a
absolutely
massive
zero
flip-flop.
political
Because the rules
power?
of the Senate
That's
are
exactly the
quite literally
critique.
hanging by a
Women
thread
literally
right now.
could
I mean,
not
the
vote for
decisions
the
made in the next
legislators
few
who
days
wrote
will
those
dictate how
1868
American
laws.
laws are written for
So
the next
doesn't this
century.
framework
Welcome to this
structurally
deep dive.
lock
Today
modern
we have a
citizens
custom
into the
mission
social
tailored
hierarchy
just for
of the
you.
19th century?
We're
Well,
going
to be totally
explore
impartial
the
here, we have to examine the
swashbuckling,
mechanics of
pirate-filled
both sides
origins
of this
the
divide.
filibuster.
Sure, let's look
It
at
is a crazy Proponents of the
history.
history
really
and
is.
tradition test
We'll
argue
also
that
break
this
down the
rigid
terrifying
framework is literally
parliamentary
the
weapon
only way
known
to
as the
maintain
nuclear
judicial
option.
objectivity.
And finally,
using
we will
historical
unpack
data
a
instead of
mind-bending
modern
mathematical
feelings.
concept
They argue
called
that if
the
you abandon
Manchin
history,
paradox.
you
Right,
leave
which
the
proves
definition
exactly
of
why
liberty
politicians
up to the
use
whims of
gridlock
9
as a
unelected
highly
judges.
calculated mathematical
Without a
strategy.
historical anchor,
So,
justices
by the end
might
of this
just
conversation,
invent new rights out
you
of
will
thin
hold the
air
secret
based
decoder
purely
ring
on
for the
modern
chaos you see on the
sociological
news.
trends
You will
or,
understand
their own
the
personal
hidden
policy
game theory
preferences.
that
So
drives
history,
these
despite
high-stakes
its obvious
showdowns.
flaws,
Absolutely.
Provides
let's
a
unpack
stable,
this.
verifiable
Before we can
metric.
truly
Exactly.
grasp the physical
But on the other
threats
side,
and
the critics
massive
argue
stakes
the data
of this
itself is
2026
poisoned by
FZB America
historical
Act standoff.
disenfranchisement.
Right, because
We
if
really
we was
need to look at what the
excluded from making
filibuster
those laws.
actually is.
Exactly.
And more
Using
importantly,
the
how it
1860s
started.
as
Right,
the
because it
ultimate
wasn't designed
baseline
this way
forces
by the
historically
founders, right?
subordinated
Like, this
groups
wasn't
to
in the
live under a
blueprint.
Not at
definition
all.
of
If you
liberty
read
that
the
they
U.S.
had no voice in
Constitution,
shaping.
you will not
It's
find the word
fascinating.
filibuster
The University of
anywhere in
Florida
the text.
analysis
Wow,
suggests that
nowhere.
this framework
Nowhere.
creates a
The
constitution that
Constitution
fails
basically
to
gives the Senate
represent
the
the
authority
free
to
and
set
equal
its own
status
internal
of
rules.
contemporary
So
society.
back in
Yeah,
1789,
the tension is really
during the
between
very
a
first
system
sessions,
that limits
debates
judicial
ended with just a
overreach
simple
and a
majority
system
vote.
that accounts
Okay,
for social
so
evolution.
51 votes
And
you're
that
done.
friction
Exactly.
really brings us
But
to the
there was this
ultimate
massive
promise of this
loophole.
entire system.
They
Yeah.
never
I mean, when you walk up
codified
the
a
steps of the
specific
Supreme Court
procedure
building,
to force a
etched
vote
right
to
into the
happen
white
if
marble
someone
above the
simply
columns are the
refused to stop
words
talking.
equal justice under
So without
law.
a mechanism to cut
And
off
that
debate,
concept is so
politicians figured
foundational
out
to
they could
Western
just,
civilization.
hold the floor
I mean, its
hostage.
origins
He did.
actually trace
We
all the
actually
way
have
back
diaries
to the
from the
Greek
very first
general
session of the
Pericles
Senate.
in 404
Pennsylvania
BCE.
Senator
Really?
William McClay wrote down
404
his sheer
BCE.
frustration that
he
senators
observed
from
that the
Virginia
laws
were
afford
intentionally
equal justice
talking away
to
the
all
clock.
in their private
Just to make sure a
differences.
specific bill
And
couldn't
every
pass.
Supreme Court
Right.
justice
They
today
literally
actually
weaponized
takes a
the
judicial
clock.
oath
I mean, if they were
expanding
holding
on
the
this very
legislative
idea.
process
They
hostage,
swear
it makes
to,
perfect
quote,
sense why the press
administer
eventually started
justice
calling
without
them
respect to
pirates.
persons and
Which
do
brings us
equal
to the
right
actual
to the poor
word
and to
filibuster.
the rich.
It's a
Yeah,
beautiful
it's easily
ideal.
one of the
But
strangest
looking
words
at the
in American
mechanics we just
politics.
dissected,
So where does
the
it come
strict
from?
scrutiny hurdles,
The etymology
counting
is
of
fascinating,
1868
honestly. The
statutes,
term
the
really
19th
took
century
hold in the
precedents.
1850s.
Does that
It
ancient
comes from
ideal
the Dutch word
actually survive the
reboiter
modern
and the
meat
Spanish
grinder of the
word
Supreme Court?
filibustero. It's a great
which
question
translates
because the
directly to
sources show
freebooter
us
or
how
pirate,
often
right?
procedure
Yes.
actually suffocates
Specifically,
substance. Truth
the
rarely
mercenaries
adheres
and
perfectly to
pirates
theory.
who
we
raided
recently saw
Caribbean
this play out
islands and
vividly on
Latin
the Supreme
American
Court's
countries
order
during
list.
that era.
Yes.
So
The
they were
James
calling these
Skinner
distinguished
case.
senators pirates.
Justice Sonia
Pretty
Sotomayor
Sotomayor and
The
Justice
term
Ketanji
entered the
Brown
political
Jackson
lexicon
issued this
because
incredibly
observers
sharp
recognized the
dissent
behavior.
regarding Skinner.
Senators
So Skinner
who
and
talked
his
for
co-defendant were
hours
convicted
were
of
literally
murder.
hijacking
But then something
the
came
Senate
to light
floor.
later.
Like taking the government
Exactly.
hostage, just like a
Later,
pirate
it was
taking
discovered
over a
that
ship.
Louisiana
Exactly.
prosecutors had
So
actually
let's track how the
hidden
Senate
favorable
tried to
evidence
fight off
from
these
these
legislative pirates.
And
because of this
because
suppressed
as the country
evidence,
grew,
the
you
co-defendant
couldn't just
had
have
his
one
conviction
person shut down the
vacated.
entire government for
So
weeks
the
on end.
state
No,
admits
you
it
couldn't.
cheated, but it
And
took a
one man
long
goes
time to build a
free.
defense.
Right.
By the
But
early
what
20th
happened to Skinner?
century, these
Skinner
marathon speeches
remained in
became
prison.
Which is
catastrophic
insane.
for a
It is.
modernizing
He could not
nation.
get
I
the
can imagine.
required
So
4
finally,
votes
in
from the Supreme Court
1917,
to even
President
grant
Woodrow
a
Wilson
hearing for his
pushed
appeal
the Senate to adopt
because he was
Rule
basically
22.
trapped by procedural
This rule
technicalities.
created a
Procedural
formal
due
process
process
called
basically
cloture.
overrode his
Cloture,
substantive
yeah.
rights.
Which is simply a
Exactly.
mechanism
There are
to force
laws
an
like
end to
the
debate.
Anti-Terrorism
But
and Effective
here's the
Death
catch.
Penalty Act,
It
which
required
place
a
severe
massive
restrictions on when
two-thirds
and how
majority
federal
vote to
courts can
trigger.
review state
Wow,
convictions.
which is an incredibly
And
steep hill to
because Skinner's
climb.
legal team
So
missed
stiff
certain
that over
procedural
the next
windows,
4 decades,
the court
the
just
Senate
declined
only
to
managed to
intervene.
successfully
And that's
invoke
why
cloture
Sotomayor and
5
Jackson
times.
wrote that scathing
That
dissent.
is wild.
Yeah.
They argued
Southern
that
senators
prioritizing
famously used this
procedural
exact
finality
tool
over
to
obvious
block
innocence
civil rights legislation
violates
for
the
years.
very
The
principle
gridlock
engraved
grew
on their
so
building.
intense that in
Equal
1975,
justice under
the
law.
Senate lowered
That
that
is a
threshold from
staggering
2/3
reality.
down to 60
A man
out
remains
of the
locked in a
100
cage,
total senators.
not because he's conclusively guilty,
okay.
but
And that
basically
60
because his
vote
paperwork
threshold
was
is the
out of
number
sync
that
with
dominates our
procedural
politics
timelines
today.
while his
Exactly.
co-defendant
But here
walks
is where I think a
completely
lot
free.
of people get
Yeah.
confused.
And we see
When
these
we hear
wild
the word
variations in
filibuster,
how the
we
court
don't just think of a
administers justice
60-vote math
across
problem.
different issues too.
We picture
I mean, the
Jimmy
recent Childs
Stewart
v.
in Mr.
Salazar
Smith
case,
goes to
the court
Washington.
issued
Right,
a
the classic
totally
movie
lopsided
scene.
8-to-1
We
ruling,
picture a single
striking
person
down
standing at a
Colorado's
podium,
ban
reading
on
the phone
conversion
book,
therapy for
sweating,
minors,
refusing to
finding
sit
a
down.
clear violation of
But
free
senators
speech.
rarely
Right,
do that
an 8-to-1
anymore.
consensus.
Why don't they have to
But
physically
then,
talk today?
the court
That
remains
is a
deeply
crucial
and
piece of the
bitterly
puzzle.
fractured
So
over
in the
cases like the Terry
1970s, the
Pitchford
Senate
appeal in
created
Mississippi,
something called the
which
two-track
involves
system.
decades-old
Two-track system.
patterns
How
of
did that
racial
work?
discrimination
before
in
the
jury
system,
selection.
a
Which
filibuster
perfectly illustrates
stopped
how
all Senate
equal
business
justice under
completely.
law
Nothing
actually
else could
operates
happen.
in practice.
The Senate
It's the
realized
guiding
they had a
principle,
whole country to
absolutely,
run,
but
so
it
they
is
changed
constantly
the procedure
sheltered
makes
through the
sense.
rigid mechanical
Under the
tests
new
we
system,
discussed
if a
today.
senator simply
When the court
threatened
relies
to
heavily
filibuster a
on
bill,
19th century
the Senate
traditions
leadership
to
would just
dictate
set that
modern rights,
controversial bill
ensuring
aside on a
equal
different track and
justice
move on
for
to
contemporary
other business.
citizens
Oh, wow.
becomes an
So they
incredibly
made it
complex
painless.
balancing
You didn't have
act.
to stand up
The
and destroy your
machinery of the
vocal cords
law,
anymore.
the
You just
tiers of
sent an
scrutiny,
email
the
saying,
historical
I
audits, the
object, and the
procedural
bill was
limits.
frozen.
It often
Like a
dictates the
silent
outcome
filibuster.
long
You
before
capture the
concept
dynamic
of fairness
perfectly. The
even
physical
enters the
endurance
courtroom.
requirement
It's like the
basically
map we are
vanished.
using to navigate
But the
modern
fiscal
fairness
records
was from
literally
before
drawn
and
150
outside that
years ago.
silent
That's
system.
exactly what it is.
Those
today,
remain pretty
we
legendary.
started with
Oh,
the
absolutely.
immediate,
Strom Thurmond
real-world
spoke against the
stakes
Civil
of the
Rights
Trump
Act
v.
in
Barbara
1957
Birthright
for
Citizenship
24
case,
hours in
where the
1850.
administration is
Imagine finding out
arguing
your
for
elector who
hours.
even gets
It's
to
the
step
modern
inside the
individual
government
recognize
massive
Cory
spending
Booker.
addiction.
Right.
We
It
dismantle
does.
the underlying
In
machinery
April
of the
2025,
process,
Booker
which
spoke
acts
for
as
an
the
astonishing
invisible magic
25
detector
hours
that
and
the
5
government has a
minutes
compelling enough
against the
reason
policies of
and
the
away
Donald
your
Trump
liberty.
administration.
And we
I mean, just
explored
think
that
about the
highly
blockade
controversial
over
history in
hard
tradition
25 hours.
tests,
This money
where
was
judges
cannot
actively
be
fought in the
forgotten.
laws of
We
the
cannot
1800s.
deaths.
You
set
can't
up
even
at
leave the
exactly what
chamber for
fundamental rights
bathroom
we
break.
possess today.
It is a
house
is gonna
brutal,
collapse.
And to
dangerous
understand the
existential
mechanics
crisis for
of
the
these
House.
legal
Exactly,
tests
and
is
to
really
save
the
the House
ultimate
fund.
key
really
to
reminds
being
me
an
of a
informed
passenger on a
citizen.
speeding train.
The
Spend a
debates
little
are
time
fierce,
groceries,
and
you've
the
got bills
rulings
piling
impact
up,
everyday
emergency.
life
So what do you
for all
do?
of us.
Everyone
You
else
raise
into
the
the
cannot
walls just because they
advocate
don't
that
like
money
the
and pay off
final
your credit
destination.
cards and tell your
It is
family,
a
hey, don't
highly
understand
disruptive
the underlying
maneuver.
engine
Wait,
that's
that raises
driving
a
this
glaring
scenario,
question, though. The
if
roof is
this
the planet.
rule is
So we'll leave you with
Maryland's
this final
climate
thought.
rules.
Mm.
If
And
the
the
Supreme
Supreme
Court
Court
relies
relies
strictly on the
strictly
traditions of the
on
past to define the right to the present, why have
does
they
a
constantly
constantly
evolving
evolving
society
avoidable
That
that
is
ensure
the
equal
core
justice
Welcome
tension
to the
of
deep
the
dive.
very
United States
identities
Senate
today
right
we're
now.
exploring
The
all
reason the
classic
filibuster
cases of
survives
fiscal
is
sleight of
that
hand
permanently
coming out of
destroying it
Minneapolis.
requires a
Think
maneuver
about whether
so
that is
extreme
strategic
and so
energy
destructive to the
investment adapting to the
institution
future
that it earned a
or anchoring us
terrifying
to the
nickname.
huge pot of money. Thanks for joining us.
Exactly.
Save the
The
entire
nuclear
dive into
It sounds like a Cold War tax.